Limitation Act 1963. So this is lesson number 7. So in lesson number 7 we study what is Limitation Act, and this is one act which I really like because it is very interesting and also fairly simple. What is Limitation Act? Limitation Act talks about one very simple thing. If you remember that, full act is going to be very easy. That is why in this introduction I want to tell you that. What is Limitation Act is simply and nothing but the time limit within which you must file a case. For example, September 25th is the last date to pay the exam fees, and with some additional fine you can pay till October 10th. Same way, if you are writing the exam, let us say in the month of June, you have to pay your exam fees by March 25th, and with late fees it is April 10th. If you pay after that, what can you do? You cannot write in that attempt, you should write next attempt. Exactly. Same thing even in our Limitation Act. The act says very simple, for which kind of case, what is the maximum time limit within which you can file a case. Suppose today somebody has robbed your house. Will you go to the police station after 1 year? Definitely not. So exactly like that, for every kind of offense, there is a time limit within which you have to file the case. For example, if it is a appeal to the higher court, the time limit is within days, let us say 60 days or 90 days, things like that. If it is a normal case, usually it is 3 months from the date of the offense or date of the problem. And in rare cases, the time limit is even up to 12 years from the date of the offense or date of the commission, date of the actual situation or the act which has happened. So that is the reason why don't think that the limit is the same for everything. For different kind of offense, for different kind of issue with respect to the act, for different kind of non-compliance, we have a different time limit. Here it is not important for you to remember what is the time limit for which kind of offense. What is important is, first thing, to know what is Limitation Act, why do we have Limitation Act, and what is the uses of Limitation Act apart from the concepts in Limitation Act, like what is the maximum time under which you can file the case, what is bar on limitation, when the time begins to run, because I told you from the date of commission of offense, but technically we should understand what is the first date from which we should calculate this time limit. All this we study in Limitation Act. Tomorrow as a company secretary, you should advise your management that if there is any case, that what is the time limit within which they can file the case. So that is why this act becomes useful. There are some exceptions also. In some cases the time limit can be extended. So how do we extend the time limit? So there we call as reasonable cause or sufficient cause. So if you have a strong enough reason which is justifiable, which is allowed by Limitation Act 1963, even after the time limit you can file the case, and that is what we study when we study sufficient cause or reasonable cause for the delay in filing the case. Of course we will study that in detail, but now I am just giving you an overview. Then we study what is the time which begins to run, how and when the time begins to run, and what is the procedure for calculation. In Limitation Act there is one more thing. Once the time starts to run, there is no stopping. That is continuous running of time. So if I start calculating day number 1 today, day number 2, 3, 4, 5 continuous, there will be no break in between. So once the time begins to run, nobody can stop it. There are multiple cases and scenarios which we study in this chapter, for which kind of case, what is the time and when it begins to run. And also in the end of this chapter we have an annexure which talks about the different time limits. You don't have to remember everything. Try to remember at least 4 to 5. I will also tell you how you can remember it and what is the simple method which will be very useful for you. That was the introduction to lesson 7. Now let us start studying all the sections in Limitation Act which is there in your syllabus. Limitation Act of 1963. What is this Limitation Act of 1963? This is basically the time limit within which we must file the case. So the Limitation Act talks about what is the time limit. So what do we learn in this particular chapter? What should we know? So this act is mainly about the time periods within which we must file a case. So the time limit. So suppose there is some problem today, there is a issue which has happened today, I want to go to court. So there is a time limit which the law is prescribing for me to go to court. Now, if suppose somebody slaps you today, will you come after 1 year and tell you slapped me, I'll take action against you? You'll immediately do some action, correct? Something as simple as that. Same way, for every kind of case, you need to take action within a reasonable time. What is that reasonable time is given in this act. This act applies mainly to civil proceedings and for some special criminal proceedings. So first we should know to whom does this act apply and for what kind of cases it applies. So what we should do is try to understand the time period within which a case has to be filed, and we should know within which the person can get the solution easily. So we need to know how and when we should file the case, and that is the main thing. First, let us look at what is the meaning of limitation. Limitation, the very word limitation means a limiting rule or circumstance, a restriction. So a restriction. So if somebody comes to you, for example, best thing is college admission. So college admission has some time limits, correct? So they will say last date, including CS admission, anything. So last date is, let's say 31st March, they will tell. So within 31st March, you must do the particular payment of fees. If there is no limitation, then people can take action anytime. That is why we need to have a limitation, and this is the English meaning of limitation. We have still not yet come to the legal meaning. In English, it simply says a limiting rule or circumstance, a restriction. So a restriction is given. So what is limitation in law? In law, what is it? A legally specified period beyond which action may be defeated or property right does not continue. That means within the time limit you must file the case. So when we say limitation in law, it means it is a legally specified time limit. So according to law, they are giving you a time limit. So you can simply write the time limit according to law. For what? For filing a case in court. As simple as that. That is what it is. Now that you know what is limitation, we need to know what is the time limit and why this rule is even there. So what kind of limitation? It may be like 1 year, 3 years, 60 days, 90 days, whatever it is. For example, you are going for appeal. For example, High Court appeal, things like that. There you may have 60 days time limit. Supreme Court, in rare cases, you may have 90 days time limit. But if it is some other offences, you have 1 year or 3 year or even 12 years. So depending on that. So what we need to understand is that the bad news is time flies, the good news, you're the pilot. You're the pilot means in law, it simply means that you have to take action to file the case. Okay? Time waits for nobody. That is what the Limitation Act is telling. So within the deadline, please file the case. So if you file the case after the deadline, you don't have any legal legal right to exercise your remedy. Okay, you may be correct, the law may be on your side, but the time limit is over, the deadline is over, so please file. So in Limitation Act, just to give you an example, once the time starts to run, there is nobody can stop it. So if you look at mythology, we had Lord Rama. So Lord Rama, once he takes his bow and arrow, he will definitely use it. So if he takes the arrow, he'll always use it. If you know the mythological stories, you'll understand this. Same way, just like Lord Rama, we need to understand that in Limitation Act, once the time starts to run, nobody can stop it. So once Lord Rama will take the arrow, he will not keep it down. He will definitely use it. Same way we need to understand here. So time limit to file a case is specified in the Act. So what is the last day to file? You should look at the Act, and if you file after that, you don't have any legal remedy. So no legal remedy if you delay the period in the Limitation Act. So you must file the case within the time limit. So in simple words, so far what I have told you, Limitation Act talks about the maximum time within which we must file the case. So let us look at the introduction. So here the Limitation Act prescribes limitation for suits, petitions and applications. So any form of case.
This act applies to the whole of India except Jammu and Kashmir. So it is not applicable to Jammu and Kashmir, it is for the entire India. So Jammu and Kashmir has special status, it is definitely part of India, but because of our historical issues in Jammu and Kashmir, we have given it special status. So some acts are not applicable there. They may have their own act which will be passed in the Jammu and Kashmir legislature. So limitation bars the remedy in court but does not extinguish the right. This is very important. So like I told you, suppose there is a time limit and you do not exercise your right within the time limit, your right is not lost, but you don't get the solution. You are right, the law is on your side, but you cannot do anything with it. So though if you have it, it is of no use. It is because the limitation law simply says that it is not taking away your right. Don't think after that time you don't have right, but you don't have a legal remedy in the court. So if there is out of court settlement after the limitation period, it is valid. So this is very important for you to understand. We are talking about only the time limit to go to court and to get a legal remedy within the court and the judicial process. But after that time limit, if all the parties are having mutual consent and they will solve the issue out of the court through negotiation or mediation or something, it is perfectly valid. There is no problem. This is very important for you to understand. You should know this really well. Okay, in Limitation Act, don't think, okay, time limit is over, I don't have any rights. Please remember there are two things. One is rights, the second one is remedy, the legal remedy. So the rights will continue to be there even after the time limit, but the legal remedy to go to court is lost. That's all. So as I have put it here, you can please remember, out of court settlement after the time limit of limitation period is perfectly valid, 100% valid. So why is this valid? Because your rights is never lost. In law, if you are right, your rights will never be lost. If you are on the right side of the law, there is nothing for you to worry. Only you might not be able to file a court case, but if you can convince the other party for out of court settlement, it is valid. Now that we have a clear understanding of the introduction, let us move to the computation of the period of limitation. So how do we calculate this? What is the time limit and how do we calculate this? So the Act prescribes the period of limitation in articles in schedule to the Act. So there is a schedule to the Act, we can have a look at it, and there it prescribes the time limit. That is the first thing. The articles prescribe limitation period for specified case, that is specified kind of suit, and also mainly time from which the period commences. What is that? That is the most important thing you should know. From when is that time limit going to start? That we will look at the articles in the schedule. Next we come to section number 3, bar of limitation. Court should not proceed with the cases or suits made beyond the period of limitation. So this is the responsibility of the court. So if the schedule, just now we studied that there is a schedule to the Act. So if the schedule says 1 year, after 1 year the court should not take that case. Very simple. Limitation should be decided on the facts as they stood on the date of presentation of the case. Plaint is nothing but the application for the case. So whatever we decide, it is decided on the facts as on date of the case. The court can suo motu take note of the question of limitation. That means nobody need to apply to the court or nobody has to complain. The court on its own motion, the court can take note of the limitation period and then they can reject the case if it is beyond the time limit. Next we come to extension of time, what we call as doctrine of sufficient cause. So sufficient cause is the time limit which can be extended if there is a genuine reason. Now if you have taken leave in school, next day you go, you tell, oh sorry, then somebody in the family was not well, I could not come, then okay, the school will tell, okay, it's a genuine reason. If you tell, sorry, my favorite movie released and that's why I could not come, your teacher will get very angry, correct? Which is more important? A family member not well is more important than watching some movie and missing the school, correct? Same way, even if you can't file the case, if you can show the genuine reason or what we call as the justifiable reason, it is a sufficient cause for the time limit to be extended. So section 5 of the Act talks about this. It gives extension of time in certain cases on sufficient cause being shown. So you should show why there is delay, and the delay reason should be valid. Applicant should satisfy the court that he had sufficient cause, valid reason for not appealing within the time limit of the Limitation Act. So he should tell why he could not come. Example, the applicant was misled by the order of the court, judgment of the High Court, in ascertaining or computing the prescribed period. So if there was a misleading judgment, or if it was any confusion in the order, then there is a sufficient cause. He will be getting the time after the time limit also, but the court is having the final authority. One more thing, the section is not applicable for applications which is made under any of the provisions of the Order 21 of the CPC, and also to suits, because they already have 3 to 12 years. So when we have 3 to 12 years, you are not going to get extra time for sufficient cause. You cannot say no, somebody was not well, something genuinely happened. You cannot. Anyway, we are giving you 3 to 12 years. You cannot delay. Okay. But for other cases, you can show the sufficient cause. For applicability of section 5, the prescribed period should be over. That means, suppose somewhere it is said that 6 months is the time limit. After this 6 months, after this period, you should go to court, and then you should say sorry. You should not say another 2 months is there, but anyway I cannot file the case, so now only I am going to take extension of time. No, this is not going to work in this particular Limitation Act. In many other laws, within the time limit you should take extension. For example, in company law, AGM. For extension of AGM, you should apply before the AGM date. Okay, but here for extension of the time, we must have a period which is over. The time limit should be over. After that, you can apply for sufficient cause for extension. Sufficient cause is nothing but asking for extension. Sufficient cause has not been defined, but it depends on the circumstance of each case. See, sufficient cause cannot be defined also. Why? How will you tell? There are 100 variables which will happen in the world, correct? And all of them may be genuine reasons. So you cannot give a list or a definition. Each circumstance is different. The judge will decide whether it is sufficient to extend the case or not. Now let us look at some of the examples for sufficient cause. Yes, wrong practice of High Court which misled the appellant. So High Court only has misled. Okay, sufficient cause will give you extra time for filing the case. So what is the meaning of examples of sufficient cause? When we get extra time to file a case, that's what it means. Wrong advice given by advocate. Advocate is only giving wrong advice. Okay, the judge will agree that I will give you extra time beyond the time limit of the Limitation Act. So generally Limitation Act gives the time limit. More than that time if you want, if this has happened, the judge may give. Again, please remember, it depends on the circumstances of each case. Just because this has happened, not that the judge will definitely give. It is a chance. That is what you should know. Imprisonment of the party or serious illness of the party. So if you imprison the party, then also there is sufficient cause. Then time taken for obtaining certified copies of the decree of the judgment. So after the judgment is there, you take some time to get the official copies, which we call as certified copies. That time is okay. If that is delay, you will get the extension, especially if it is time limit is 60 days and all. Sometimes it takes a long time, so that will be useful. Another example, ailment of father during which the period the defendant was looking after him has been held to be sufficient and genuine cause. So this is another example. In one case, father is not well, so that is why the person could not file the case. It is 100% allowed as a sufficient cause. Of course, it is again the discretion of the judge. Judge should get convinced. Next we come to the concept of persons under legal disability. What happens to the time limit when there are persons under legal disability? Do they get extension? How does it work? Where the time period of limitation expires before the cessation of the disability, he will be entitled to a fresh period of limitation after cessation of the disability, subject to the condition that it does not exceed 3 years from the cessation of the disability. So this section applies to all the suits except suits to enforce rights of preemption. So what does it mean? I'll give you an example of minor and major. So that time you'll understand this. Very simple. Suppose some person is 17 years. That means he is a minor. Okay. Now when he becomes 18 years, he is a major. That time what happens? When the time period of limitation expires before the cessation of disability. So suppose the time period of filing a case, he is 17 years and 6 months he is there. He cannot file the case because he is not at a major. It is not allowed for him to file the case. Okay. The time limit is also over when he is 17 years 6 months. That time what happens? He will be entitled to a fresh period. This is important. When after cessation of the disability, subject to the condition, it does not exceed 3 years from cessation. That means when he is 18 years, from 18 to 21 years. In my example, why? 3 years. So even if the time limit is over when he is 17 years 16 months, time limit is over. Okay. But because he is having a legal disability. What is his legal disability? He is a minor. Minor cannot file a case. You have to be major. That is even under Indian Contract Act. Correct? That is why when he becomes a major, what happens? He is losing his legal disability. What is his cessation of disability? What is his legal disability? He being a minor is his disability. Disability doesn't mean I don't have leg, I don't have hands. That is different. In law, when we say disability, what you are not allowed to do in the law, that is disability. That's all. Okay. So his legal disability is there. Once he is 18, though the time limit is over when he is 17 years 6 months, from 18 to 21, that is 3 years from the cessation of disability, he will get the time limit to file the case. Subject to the condition, it does not exceed 3 years, so maximum 3 years. So this one will be decided by the court. So this is very important for us to know. The disability must exist when the right to apply accrued, that is at the time from which the period of limitation is to be reckoned. Extension is not more than 3 years from the cessation of the disability, as I told you. So suppose there is a case when he is 17 years, this case will happen and the time limit is 6 months. But he cannot file the case. But when he turns 18, he gets the extension of the time. But maximum extension he gets is 3 years from that time. What is getting extension? To file the case, that's all. Whether he win the case, lose the case, we don't know. To file the case is getting the extension. Next we come to the important concept, very important for exam, is continuous running of time, section number 9. So what this continuous running of time simply says that once the time begins to run, nobody can stop it. That is what is told in section number 9. Once the time begins to run, nobody can stop it. That is the concept in Limitation Act. So no subsequent disability or inability to institute a suit or make an application can stop it. So suppose from today I have to file a case within 1 year. Nothing will stop the time from today. In 1 year I have to file the case. That is what it means. Simple. When any of the statutes of limitation is begun to run, no subsequent disability or inability will stop this running. No matter what happens, it will continue to exist. The applicability of this section is limited to suits and applications only and does not apply to appeals. So please remember, for appeal there are some times which are not counted, but for suits and application the time begins to run immediately to calculate time limit to file the case. Whatever we are studying, just remember what are we trying to understand. Time limit to file the case. Please don't forget that. Next, cause of action or the right to move the application must continue to exist and subsisting on the date on which the particular application is made. So here cause of action means what? Basically the reason for which the case has even started, or the right to move the application, your legal right to make the application, to file the case, must exist. This is important. On the date where the particular application is made, that time the time will begin to run. If there is an infringement of the right of a particular time, the whole cause of action will said to have arisen then and there. So if there is infringement of a right, so anybody's right has been violated, correct, that time the cause of action is said to have arisen and then the time begins to run. Only cases where cause of action continues to exist, this is very important, only cases where cause of action continues to exist, this section is coming into picture. So now that we know the section 9, once the time begins to run, nobody can stop it. What does it mean? Means in Limitation Act, section 9 says that once you start calculating the time, nobody can stop it. So coming to the next concept, computation of period of limitation. So how do we calculate? So that is given in our section number 12 to 24. Section 12 to 24 it is given. Let us have a look at it. What we should count, what we should not count.